Okay, everybody. Hopefully everyone that wants to have trickled in has trickled in at this point. In case you didn't hear me initially, my name is Mark Krause. I'm an attorney with Copenbarger and Copenbarger. I'm very happy that you folks chose to be generous with your time and join us today. We will be discussing estate planning power, how to protect your legacy, and I'm going to be going over a lot of the ins and outs of estate planning and how to go about protecting your legacy. A couple things right off the bat. I will be answering questions, but I'm going to save questions for the end. So if you would like, you can put your questions in the Q&A is probably the best place. If not, I will check the chat as well at the end. And there will be other people checking these as well, but I'm going to just save the Q&A part for the end. I will stay on the line and answer any questions that you folks might have at the end. So if you wouldn't mind bearing with me, I will go ahead and begin now. Again, there's me, Mark Krause, estate planning attorney. Before I start, I should also throw out a little bit of legalese here. This information is being provided for educational purposes only and should not be considered legal, accounting, or tax advice. Instead, it is intended as general guidance. That's just a good bit of lawyer CYA that we have to do. But there is a purpose. This is general advice, and I do want to highlight the fact that everybody's situation is unique. This is going to be advice that applies in general, but everybody has specific situations and nuances, which is why it's a good idea to see an actual attorney. Hopefully you can use this opportunity to come in and see us and utilize the free appointment that you'll get for attending the seminar, and we can discuss your particular needs in depth so that we have an estate plan that's uniquely tailored to you. One of the advantages of Copenbarger and Copenbarger, many firms in this space are basically one guy or maybe two guys. We have 12 full-time attorneys across multiple different departments. I'm with the estate planning department, but we also have a business and tax department. We have an estate administration department with 5 full-time attorneys, and we have an estate litigation department to cover hopefully all the needs that would be surrounding your estate plan and the implementation of your estate plan. We also have a wonderful staff that supports us and makes us attorneys look good every day, as you can see here. And we have 8 offices to meet your needs wherever you might be at all across California. So on today's agenda, we're going to be discussing the key documents that comprise an estate plan. We're going to go into some of the ins and outs of the differences between wills and trusts. We're going to discuss the consequences of failing to have an estate plan. We're going to talk about how an estate plan protects you and avoids court involvement. We're going to highlight some common pitfalls that people can run into when they're doing estate planning and discuss how life changes can trigger the need to relook at your estate plan. So first, the basic documents, Advanced Healthcare Directive, Durable Power of Attorney, Living Trusts and Wills are some of the basic documents. Conservatorships and probates are not the documents themselves. They're the sort of dirty words of the business that we're actually trying to use these documents to avoid. So the first document I'm going to discuss is an Advanced Healthcare Directive. What an Advanced Healthcare Directive basically does, first, hopefully we all know what HIPAA is. HIPAA is legislation that kind of functions like attorney-client privilege, but with doctors and hospital staff and medical staff. It restricts their ability to share any of your medical information with anybody. It puts a very strict confidentiality requirement on them. So the first thing a healthcare directive is going to do, if it's properly drafted, is give someone an exemption from HIPAA so they can find out what's going on with you health-wise. Second, it's going to give that person authority to use that information to make medical decisions on your behalf. And third, there's going to be certain advanced wishes that you're going to lay out that the person you've chosen is going to be responsible for carrying out, things like what's going to happen to your remains after you pass away. We do say that everyone over the age of 18 needs a healthcare directive. You might think that you get to just step in for your child that recently turned 18 and continue to have an exemption from HIPAA and be able to make all their medical decisions for them, but that is not true. As soon as your child turns 18, you do not have an automatic exemption from HIPAA, and you do not have the automatic authority to be able to make medical decisions for them if they should become incapacitated and unable to make their own decisions. So it's a good idea, I think, maybe even as part of a high school graduation present, maybe even for your grandkids or somebody, consider giving an 18-year-old, a recently turned 18-year-old, a healthcare directive because everyone does need one. When it goes into effect is going to depend on the decisions you make within the document. Some healthcare directives go into effect only upon incapacity. Some healthcare directives have grant immediate authority to the person. And there's pros and cons to either decision. And there's even certain things that are a little bit intermediate in between those two. Those are something to discuss with an attorney when you're actually preparing the document, because everybody has different priorities with regards to when their healthcare directive goes into effect. Durable powers of attorney. So this can be confusing because sometimes a healthcare directive is called a durable power of attorney for healthcare. That's why I tend to refer to it as a healthcare directive. This kind of durable power of attorney is financial in nature. This is a durable power of attorney for financial assets. So it essentially gives somebody authority to manage your financial assets when you need to have someone step in and do that for you. Again, it might be a good idea for anybody over the age of 18 to have one. There's no automatic right for you if you have, say, a newly adult child who's 18 or 19. You can't necessarily just step in to their bank accounts or be able to manage any of their financial assets. Once they turn 18, you'll lose that ability. So this gives somebody the ability to make financial decisions and manage financial assets for you, essentially by letting them step into your shoes legally. When it goes into effect, again, in general, my advice is going to be that you should have a durable power of attorney that is in effect immediately, although there are certain kinds of springing powers of attorney that can go into effect only upon certain conditions being met. Again, those are nuances to discuss with your attorney. But again, it's probably a good idea for everybody over the age of 18 to have a durable power of attorney to make sure if something happens and they're not able to manage their own finances, that somebody is already in place to be able to do that if that should happen. Conservatorship. This is the first really dirty word for an estate planner, things that we're trying to avoid. Essentially, the healthcare directive and the durable power of attorney, one of the main things they help you do is avoid a conservatorship. Now, you might ask, what is a conservatorship? Usually, the only touch point sort of in the popular consciousness about conservatorships was a pop star named Britney Spears. She was obviously a multimillionaire, but a little bit kooky. So her dad decided to get a conservatorship over her to help manage her finances. But that's usually the most popular touch point that people have with it. A conservatorship is something you have to file a petition for where a court will appoint somebody to be able to help manage the healthcare decisions and potentially financial assets of a person who's incapacitated, who can't make their own decisions for one reason or another. Unlike a durable power of attorney and a healthcare directive, conservatorships require you to petition the court, which generally requires not only filing fees, but usually a hefty amount of attorney's fees. The judge has to actually grant them, and the judge will retain ongoing supervision of the conservatorship, which will typically involve you having to file a periodic accounting if you're managing the conservatee's financial assets. The court will also appoint an attorney to represent the proposed conservatee, the person for which you're trying to get a conservatorship over, and you'll have to pay that attorney from the conservatee's money as well. So you're basically, unless you find a way to do it yourself, you're going to have to pay probably 2 attorney's fees anytime you're going to do a conservatorship, and those attorney's fees will likely be ongoing to some extent or another until the conservatorship ends, which most likely is going to be when the conservatee passes away. So unlike having a durable power of attorney and a healthcare directive, having to go through a conservatorship is going to be very, very costly. It's going to involve a lack of privacy because a lot of these things are going to be having to discuss in open court, and it's a lot more, there's a lot more court supervision and court determination over what happens. So hopefully, if you do have those 2 documents together, that'll in general help you avoid at least a conservatorship. Wills. Wills are essentially the most common estate planning document that everybody's aware of. So what a will basically does is provides rules for what's going to happen to your stuff when you pass away, and it appoints or at least nominates somebody, an executor, that's supposed to be in charge of managing those assets and carrying out those wishes. I will say that wills are typically going to have to go through probate. So when you talk about nominating an executor, it's not automatic. You're nominating the executor, but a court is still generally going to have to approve that nomination. So it's not a slam dunk that the executor you've chosen will end up being your executor. That said, who needs a will? Um, and typically, and when we say who needs a will, what we mean here is who might need just a will as opposed to not need a trust. So typically, this is going to be individuals that don't own any real estate, whose estate, the entire value of their estate is less than $208,850. If you're wondering where I pulled that random number from, it's in the probate code, so I didn't make that number up. That is the threshold for when an estate requires a full probate. So if your estate is worth $210,000 when you pass away and you don't have any estate planning done, that estate will have to go through a full probate. Whereas if your estate's only worth $100,000, there are simpler and potentially more expedited processes that your loved ones will have to go through after you die rather than going through a full probate. One thing people don't always consider or aren't always aware of, parents of minor children. If you want any say in what happens to your minor children, if you're the parent of minor children, if both you and the other parent were to pass away, you need to have something called a nomination of guardian. Otherwise, you have no say in who gets to raise the children if both parents pass away. A will is typically where you're going to find a nomination of guardian within the will. So I generally say that anybody with minor children at least needs a will so that we can make sure there's a nomination of guardian in place that make sure that the court will know one day who their choice to raise their children is if that should become necessary. Key aspects of a will, like I said, a will typically is going to have to go through probate. Unlike a trust, a will not keep you out of probate. If your estate meets the threshold of that $208,850, the will have to be admitted to probate and approved by the court. Now, it will be able to control where your stuff goes, and you will get an opportunity through the will to nominate the executor of your choice. Still have to be approved by the court, but you'll at least get to nominate them. But that will have to go through the full probate process with all the time and expense that come with going through probate. Addition to that, because it goes through probate, becomes a matter of public record. I have the ability to log on the court's website if there's an active probate out there, and I can find all sorts of information about the deceased person's estate. And if there's any fighting, I can find out quite a lot about their family dynamics as well a lot of the time, because everything filed in that probate court is typically going to be a matter of public record unless there's some very specific situation where they try to get something sealed, which is really uncommon. So if you have an interest in privacy, making sure that the ins and outs of your estate and what you own when you pass away and where it's going is not a matter of public record that somebody like me can easily look up, then you're going to want to probably do a trust as opposed to just a will. Limited tax planning, there really is not much you can do by way of, sort of fine-grained tax planning through a will. It just isn't the kind of vehicle that allows you to do that. Like I said, it will carry out your wishes. It's typically going to require court oversight. Covers only probate assets. So there are certain kinds of assets that won't fall under the purview of the will. Typically, that's going to be beneficiary designated assets like 401ks, life insurance policies, 403bs, IRAs, things of that nature will be able to typically bypass probate without the will through those beneficiary designations. On to trusts, living trusts. So the basic purpose of your standard living trust, the kind of trust people are generally talking about when they're talking about doing estate planning through a trust, the purpose of a trust is to be able to set the rules and appoint somebody to be able to manage the trust assets both during life of the person creating the trust and after they pass away. Now, typically speaking, you're going to be the trustee of your own trust during your lifetime, but there's a possibility you could become incapacitated, in which case you will set the rules in your trust for who is going to take over for you when you're incapacitated and how they're to use your assets to take care of you, because you will be the only beneficiary of your trust while you're alive. The other beneficiaries will only become beneficiaries after your death. So a trust protects you both at incapacity and after you pass away. Who needs a living trust? As you might be able to discern from what I just said about wills, if you have real estate And if your estate's over that $208,850 threshold, typically you're going to need a trust as opposed to a will in order to avoid probate. Um, Other things to really consider that can be really important. Families with minor children. So with a will, you can nominate a guardian, but with a trust, you're able to do some more fine-grained detailed estate planning for what happens with regards to your assets. Uh, Sometimes you can set rules for the guardians and how they use the money. And sometimes, if you want, you can even set it up to where the trustee, the person in charge of the money, is different than the actual guardian who's going to be raising the children, such that the guardian will have to ask somebody else to use money for the children. So there's lots of more fine-grained planning we can do for minor children in a trust. Dependents with special needs. This is a huge issue that people often are not fully aware of. Um, if you have somebody collecting, so a anybody in your family or anybody that's dependent that is collecting Social Security disability benefits or similar government benefits, often those become subject. So the government essentially keeps a tally of every dollar they paid out in terms of those benefits on that person. And if they should receive a windfall through an inheritance, like if they're, a child along with the other children and they receive something through a probate, uh, the government is going to use that tally and all that inheritance is going to be subject to clawback by the government. In addition to that clawback, it could also affect the level of benefits that they're currently receiving. The government might say, hey, you just got $200,000 in terms of an inheritance. Now I'm going to lower your benefits drastically. So there can be really catastrophic consequences of somebody who has certain kind of special needs and is on government disability, collecting an inheritance without any trust in place. What we can do through a trust is do special needs planning to try to avoid all those negative outcomes. Additionally, obviously, a trust is going to, in general, avoid probate and protect privacy by keeping your business out of court. It'll allow, in a lot of cases, for certain kinds of advanced tax planning. Like I said, it addresses what happens if you become incapacitated. It helps avoid guardianships and conservatorships. The cost and time to administer a trust versus a will is something really important that we'll probably go into a little more detail in a moment. But basic timeline in Southern California or even Northern California for administering a probate. Best case scenario, you're probably looking at a year and a half. And there are many cases where the best case scenario isn't realized, and you might have 2 years. If somebody fights about it, you could have a probate dragging on for several years, really, if somebody fights about it or if other things go wrong. Whereas a trust is typically going to be able to be administered so long as it's relatively simple, often in as little as 6 months. And the cost to administer is typically going to be far less than the cost to administer a probate. It ensures your wishes are carried out in a way that's that's certainly more secure and safe than relying on the probate court. I will say, judges are not, I've done a lot of litigation and a lot of probate administration in my career, and judges are not computers. They don't just have a simple input output where they apply the law evenly. Judges are very human, and therefore the probate court process, along with every other court process, is a very human process. And there is no way to fully guarantee what a judge is going to do 1 minute to the next. So it's a lot safer to set the rules up in a trust and try to keep the administration of your estate out of the court. A trust only protects what it owns. That's something very important to realize. Setting up a trust is one part of your estate planning, but you also have to fund that trust. That means putting assets in your trust. You need to make sure those assets are actually in your trust, which how you do that's going to depend on the asset. But if those assets are not actually in the trust, then the trust won't be able to set the rules for them. It's kind of like having a constitution over a country, but not having any inhabitants in the country. The Constitution only applies to the citizens of the country. Similarly, the rules of the trust only apply to the assets that are actually within the trust. Pour over will. This is the kind of will, so you might be surprised to learn that if you do a trust with us or, with another attorney, they're still, as a part of the estate planning package, going to have a will even along with the trust. And you might ask, why would I need a will to go along with the trust? Well, this kind of will is called a pour over will. And the basic idea is that it's a contingency plan in case something important is left out of the trust. I just talked about the importance of funding your trust. If for some reason you fail to put something really important in your trust before you pass away, that's when the pour-over will becomes important. And what a pour-over will does, as the name suggests, it essentially collects any of these sort of rogue assets, or if you think of it like a leak, you've sprung a leak in your trust, it collects anything that comes out of that leak and pours it back over into the trust. So essentially, to say it another way, the pour-over will redirects any assets left out of that trust back into the trust. So your executor is going to be the same person as the successor trustee you've appointed in your trust. And the distribution provision of a pour-over will is just going to say, I want everything to go back into my trust. This is sort of the last, line of defense. In case something's left out of the trust, sometimes we can get assets back in the trust through a more simple kind of petition. But it's always good to have a pour-over will in place just in case to make sure that everything ultimately gets into your trust. But disadvantages of a probate trust, just to make sure you're not willy-nilly leaving things out of the trust just because you have the security of a pour-over will. A pour-over will typically is going to have to go through a full probate. So a lot of the advantages you had, a lot of the reasons why you created a trust versus a standalone will, you're going to lose some of those advantages by relying on a pour-over will if something's left out of the trust. Types of planning to consider. There's lots and lots. I'm not going to go into full detail because each one of these things could basically be its own webinar. And I will say, as a shameless plug, if you review our website, we do have recordings of all of our webinars and seminars, and there may be some webinars on some of these topics specifically. So I recommend that if you feel moved to, please go check that out and look up the webinars we have there. Life insurance planning. Life insurance can be a very important component in your estate plan. Standalone retirement trusts. Most people are not going to need these, but if your estate is over a certain kind of value and you have certain advanced, requirements to try to avoid tax consequences, sometimes a standalone retirement trust for, a certain kind of IRA or other retirement asset is necessary. Pet planning. This can be simple to, a little bit complex. It depends on exactly what you're trying to set up. Sometimes there's even something called a pet trust that can be set up. Sometimes it's a simple thing done within your trust, but planning for what happens to pets after you die is something to definitely discuss with an attorney if that's something you're concerned about. Addiction and substance abuse are things that we definitely are going to address within the trust, and can be there's sort of standard provisions, but we can also tailor those uniquely to your situation if that's a concern. Minors trust, as I said, the trust can do all sorts of things to address all sorts of situations with regards to minors inheriting money. Remarriage protection. There's multiple ways in which estate planning can try to mitigate against the risk of a spouse remarrying after you pass away and diverting where your assets go. We can put things in place to protect and mitigate against that ahead of time. Rental properties are a unique concern. And in fact, I will also say, as another plug, our business and tax department is a good place to go to set an appointment to discuss potentially setting up LLCs or doing other things like that for your rental properties if you have them. Special needs and education trusts are things that can be very important. I already discussed a little bit about special needs trusts, charitable and tax planning trusts, and next generation planning in general. These are all a non-exhaustive list of things to discuss when you're doing your estate plan. So now we're going to talk about a little bit more about the ins and outs of the differences between wills and trusts. Again, a will is a legal document, as I said, that can set the rules for what happened to your property when you pass away, and you can nominate an executor. You can nominate the person in charge of administering your will. But again, if it has to go through probate court, the court will still have to approve that executor. How a will works does not take any kind of effect until after death. So you can always change your will right up into the point where you die, as long as you have capacity. Like I said, it'll name both beneficiaries and it will at least nominate an executor. You can, through a nomination of guardian in a will, you can nominate who you want the guardians of your minor children to be if both parents were to pass away. But again, if your estate's over that magic number, which is as of April 2025, $208,850, it'll have to be the will have to be administered through probate court. Simpler estates with limited assets, again, are typically what we're going to be looking at for a standalone will, somebody that doesn't necessarily need a trust. Um, Somebody that doesn't have a need for ongoing asset management. Although, again, sometimes through, if we do a simple will for somebody, we're typically going to encourage them to do also a healthcare directive and a durable power of attorney to try to make sure that they're also protected against the need of a conservatorship if they become incapacitated. Again, a lot of times standalone wills are done by couples with minor children that don't yet have enough assets to necessitate potentially a living trust. They a lot of times their primary purpose is just to make sure they've nominated guardians and said what sort of assets are going to go to their children. Um, Something to consider, another kind of wrinkle in planning or an aspect of planning. Sometimes assets can be jointly owned and in that way can avoid probate. So if you have a joint tenancy on a home, or if you have joint ownership over a regular checking or a savings account, typically those are going to come with what's called a right of survivorship, such that if one person dies, the other person will automatically have 100% of that asset without court involvement. So titling things in joint tenancy is another estate planning tool. Oftentimes there can be pitfalls or disadvantages with that versus having a trust, but that is something in the sort of repertoire of estate planning that you can potentially utilize. A trust. Essentially, what a trust is a contract that you make with yourself to manage your own stuff. You look at yourself and say, hey, self, I think you're pretty trustworthy. I think I'm going to put you in charge of my stuff. And as long as you're able to do that, trust yourself enough to do that, then you can use that contract, which will be valid in all 50 states based on the full faith and credit clause of the Constitution, to keep your assets out of probate. And you can set those rules both to manage your assets during your incapacity and to decide what happens to your assets in your estate after you pass away. And obviously, you do that by nominating successor trustees after you if you become unable to be your own trustee. So, and as I mentioned, one of the primary important things to people is that it allows distribution and the whole trust to be handled outside of any supervision of a probate court. The only time your trust is going to end up in court is if you find yourself in the unfortunate situation where one of the beneficiaries or interested parties decides to litigate. There's no 100% way to prevent against litigation, but we do definitely have a robust, what we call contest clause, that is meant to deter anybody from contesting the trust. And it essentially utilizes a threat of full disinheritance that we can implement if they challenge the validity of the trust. If a beneficiary challenges the validity of the trust without probable cause, without any real merit, we can use the contest clause to potentially fully disinherit them. And so we tend to use that to dissuade people from litigating about the trust. Often, creating trust, again, desire to avoid probate court involvement. If you have complex or higher value estates, so the current, in case anybody's unaware, the current threshold for having to pay estate tax as of 2026 is going to be $15 million. So if your estate, total value of your estate falls below that threshold, there will be no estate tax due upon your passing. But if you have an estate that's worth, say, $40 million or even more, if you have an estate where you're going to have to be worried about that estate tax threshold, that estate tax is about 40%. So it's a very significant tax. So if you do have an estate where that's going to be an issue, that is definitely a reason to consult an attorney, because there are things we can do to try to mitigate and in some cases even avoid having to pay much of any estate tax. But that requires certain more complex bespoke estate planning. And we definitely have the expertise here at the firm to help you, develop those kind of strategies. Again, privacy concerns about asset distribution. If you don't want where your assets are going and what your assets are to be a matter of public record in the court system, you want to have a trust. Blended families are a situation, again, where remarriage protection can often be more important. And so you're going to want, if you have blended families, that's often a reason to set certain things in place in your trust to sort of protect and provide to make sure that maybe your kids are protected if you and your spouse don't share the same children. Special needs beneficiaries. If you have anybody that might have special needs that's collecting Social Security disability, it's absolutely vital that if they're ever going to inherit anything, that they do it through a special needs trust so that you make sure it doesn't affect their level of benefits and that the government can't claw back any of their inheritance based on what they've already allocated to the person through those Social Security disability benefits. Planning for incapacity again and long-term management of assets. You're going to need a trust to do that. So consequences of inaction, consequences of not doing any estate planning, which unfortunately, the majority of people in California that need an estate plan don't have any estate planning. Uh, Without a plan, we always say that even if you don't think you have a will, you do have a will. The state of California has already set up a will for you as a default in the California Probate Code. And if you don't put anything in place, then the state of California will control who gets to be in charge of your estate and where your assets go after you pass away. If you don't trust the state of California and the state legislature to do your estate planning for you, that's a good reason to do it yourself. I, for one, don't trust the state of California and the state legislature to do pretty much anything. I wouldn't trust them to tie my own shoes. So I certainly would not leave my estate plan up to the state of California. Uh, the court will step in and have oversight and all sorts of authority in ways both large and small over what happens in the administration of your estate. They have all sorts of discretion to make all sorts of decisions, including a lot of discretion about who gets to be in charge of your estate. The probate process can create significant delays from court involvement. You know, I am typically doing more estate planning than sort of litigation and probate administration at this point in my career, but I can tell you from experience, in Orange County, LA County, most of these counties, if you have one thing wrong on your probate petition or any of the things you're filing within the life of a probate case, and you need a continuance, you're probably looking easy at a 5-month continuance because of how backed up the courts are. So tiny little mistakes can create huge delays in the probate process. And God forbid anybody fights about anything, because if you have litigation break out during the probate process, it can drag on for several years. It's a lot more. And one thing people don't really realize is the cost. The cost of a probate, the basic cost for attorney's fees is statutorily defined as a percentage of the estate. It's not something you get to just negotiate with your attorney ahead of time. It's not based on hourly. It's based on the percentage of the estate, and it can be a significant, it can be a very significant amount. I mean, if you're talking about if all you owned was a house that's about the median California, home in California, which is somewhere around $850,000. It goes up and down. Maybe it's a little up right now. Then you're going to pay about $20,000 in just attorney's fees if everything goes perfectly and the attorney doesn't need to do anything out of the ordinary. And that doesn't even account for all the filing fees. Anytime you file a petition in court, it's going to cost almost $500 just to file a petition. There's all sorts of other costs that the attorney is going to allocate to you, everything from, paper costs and all sorts of other costs, the cost to mail, to serve people. There's a probate referee that's essentially an appraiser appointed by the court to appraise your assets, and you're going to have to pay him for the privilege of having him value all the assets in the probate. So it'll get significantly more than that basic cost of just attorney's fees. So you're looking at a significant increase in time, difficulty to administer, and cost to administer if you're going through probate. So obviously what we want to do is we want to protect your estate and avoid court. So how to minimize risks and reduce burdens. If you have a living trust and you have a fully thought out estate plan that's uniquely tailored to you, you can keep decisions within your control, minimize and hopefully completely avoid any court supervision. You can create clarity. This is something people also don't think about. If you've done no estate planning at all and you pass away, not only do you leave your loved ones with the grief of your passing, but all of a sudden they're going to have to become experts in the probate code. They're going to have to figure out what probate is, get the probate off the ground, potentially find an attorney. You're going to give them a very difficult set of tasks to figure out, all while they're going through the grief of losing you. Whereas if you set up a carefully crafted estate plan that's uniquely tailored to you with a firm, it's going to make things a lot easier on the people that are going to be administering your estate afterwards. It's going to make things much more clear and easy to administer, especially if you have it done through a firm like ours with our own estate administration department. We'll be there already, to answer their questions and help them get the process started. And when you're going through grief, anything you can do to ease that burden of figuring out what to do with your estate after you're gone while they're going through that grief is really important. And your kids or whoever is going to be administering your estate really will be grateful. Trust me, because I've seen things on both sides. Common pitfalls. Oops. Boo-boos that people make. Forgetting to update your documents. I wish I didn't see this so often, but I see all the time people coming to me that have an estate plan that was done in the 90s or, the year 2000, and they haven't looked at it since then. A lot can change in 20, 30 years, both in the law and with regards to the people that you've picked to be your decision makers and your beneficiaries. For instance, if you had a healthcare directive done in 1998, for instance, which I have seen, it's not going to probably have all the necessary verbiage about HIPAA to allow the person you've appointed to be your decision maker in your healthcare directive to be able to know what's going on with you. So that's something that you're going to want to make sure that you don't wait 20 years before reviewing your documents. We're here for you. If you do have a trust with us, for instance, you do have an estate plan, you haven't met with us in a very long time, this is a good opportunity. If you're attending this webinar, you're going to get a free appointment, and I'll discuss how that works at the end, but you're going to get a free appointment. Please use that opportunity to review with us if you haven't, if you've waited maybe a little too long to review, because there could be important changes of law and there could be important changes in your personal life that aren't addressed in that prior estate plan. Another big pitfall, relying on either generic forms or even, do-it-yourself forms. I have seen major pitfalls with this. The worst case I ever had as a litigator, one of the ones that kind of keeps me up at night, involved a fella who decided to go not through an attorney to do his estate planning, but to go through a financial planner. That financial planner did not do the due diligence to make sure that this person properly executed and implemented all their estate planning documents. And as a result, after a difficult litigation process and trial, a judge ruled that his entire estate plan was invalid, and he had disinherited children his daughters were awful criminals and truly terrible people, such that CPS a long time ago had taken all their children away, and the decedent had raised all those grandchildren himself as if they were own children. So understandably, he put an estate plan in place to disinherit the daughters and give everything to his grandchildren. Well, as a result of not having a competently executed estate plan, his daughters ultimately got everything and his grandchildren got nothing. So it was a pretty tragic situation. Similarly, I've had people come see me after trying to do something as a benefit through work. They got to do an online estate plan and just do a do-it-yourself, fill in the blanks estate plan. And again, when they came to me and showed me this estate plan, regardless of even whether it was, carefully and fully competently drafted, again, they didn't execute everything properly. So I had to inform them in that first meeting, you don't have an estate plan. This estate plan is not valid at this point, which I, took the time. We eventually redid their estate plan, but I took the time at that point to say, let's stop everything and sign this right now, so that if you get hit by a car on your way home, that you actually have something in place before we can redo the estate plan. But those are really common pitfalls of trying to rely on do-it-yourself or having non-attorneys prepare your estate plan. And a big problem, again, with having a non-attorney is prepare your estate plan. If something goes wrong, you can't sue them for malpractice. So that is a major issue. Failing to coordinate your beneficiaries. You want to make sure that this goes along with having outdated documents. You want to make sure that your current list of beneficiaries are the people you want getting your stuff. Maybe you had a close friend at one point you wanted to give something to that you had a falling out with. You want to make sure your documents are updated to account for that. Another bad idea, not communicating plans to trusted individuals. One of the bad things about that same case I brought up, luckily, the granddaughter who he had named to be his trustee found his estate plan because he never told her about it in the first place. She had to find it in a drawer while she was going through his things. So it's a much better idea than relying on somebody to go on an Easter egg hunt to find your stuff, to tell the people who are going to be in charge of your estate roughly what's in your estate plan and that you have an estate plan where to find it ahead of time. In fact, if you're wanting to mitigate against the possibility of anybody litigating about your estate later, I typically advise people to let your beneficiaries know what they're going to get, what they can expect ahead of time. Even if they don't like it, it's typically a lot worse if it's a surprise after you pass away. The number one situation where I tend to see litigation arise, with a trust or an estate plan is when there's not only really hurt feelings and, anger about what somebody's getting in the trust, but surprise where they didn't find out until mom and dad died or whoever passed away. So you can avoid at least the surprise element by letting people know well ahead of time what they can expect. Misconceptions. You might think I don't have enough assets to do an estate plan. Well, as we discussed, there's certain kinds of estate planning that you should do, even if you have very little assets. If you have virtually no assets at all, I would still say you need a healthcare directive, and there's still a decent chance you might need a durable power of attorney for financial. If you have minor children, even if you have very little assets, I would advise you to have not only those documents, but a will, so that you can at least nominate guardians. But of course, if you think you don't have enough assets, but you have an estate that's worth more than $208,850, then you're probably wrong about that, and your estate will end up in probate court unless you create a trust for yourself. I'm too young or too old. Death, morbid fact of life is that death comes for us all. We're all going to die someday, and accidents can happen any time. Everybody needs an estate plan of some kind, I would say. There's nobody too young or too old to not have some kind of responsible plan in place, because anybody can pass away or become incapacitated at any time. And even if you just become incapacitated for a limited amount of time, if you go to, get in an accident and go into a coma for a bit, a lot of havoc can be wreaked if no one has the ability to make decisions for you during that time of incapacity. So it's just a responsible thing to do, to set up a plan to provide for what's going to happen, both for your incapacity and if you pass away. My family will figure it out. Families going through grief, as I mentioned, going through the real acute grief of losing you, especially if they're not already attorneys that practice in this space, are really not equipped to just figure it out very easily. If you leave everything to them to figure out, it's going to cause a lot of problems. And the worst thing is it could result in litigation. And a lot of times where, nobody has a plan in place, I have seen it really destroy families. And that's, probably, I would imagine the last thing that you're going to want is that your family to devolve into acrimonious and bitter fighting that breaks up the family after you pass away. So having a clear, carefully tailored to you estate plan in place can really mitigate against the possibility of that happening when you pass away. One document is enough. No, one document is typically not going to be enough. I think hopefully I've tried to explain how these documents work together to form a coherent estate plan to provide not only for periods of incapacity, but what happens after your death. One document typically is not going to be enough to cover all those various situations. Life changes. These are things that you're going to want to look out for that are definite triggers to please review your estate planning. Marriage or divorce. If you get married, obviously your life has changed drastically, and that same old trust you might have done as a single person is not necessarily going to be an adequate full estate plan now that you're a unit, now that you've gone from a you to a we. There's a whole lot more considerations that you're going to want to consider and have the estate plan hopefully evolve with that situation. So I definitely recommend, if you're going to get married, if you recently got married and you have not looked at your estate plan, please come schedule a time to come look at that with us. Divorce. Obviously, if you have a divorce and you're disentangling your life from your spouse, if you both had a joint trust, that trust essentially needs to be dissolved and two new trusts need to be created. We need to do two full new estate plans now that we're disentangling your lives in the sort of marital unit that you previously had. So if you're getting a divorce or you've gotten a divorce, please come revisit your estate planning at that point. Birth or adoption of a child, that can greatly affect how you have things set up in your estate plan, especially the transition from going to 0 children to becoming a parent. You're going to want a nomination of guardian in place No matter if you just have a simple will or a full, revocable living trust. If you didn't do a nomination of guardian because you didn't have any kids before, having kids should definitely trigger you to come in and plan that out and maybe do some more fine-grained planning about how exactly we want to set things up for your kids if you were to pass away while they're still minors. Death of a loved one. That loved one might be an important person that's a linchpin in your estate plan. If you lose somebody like that, again, that's a good reason to come in and revisit your estate plan, maybe decide how to replace them or who to put in a place, how to alter your distribution scheme. The death of a loved one can greatly affect a lot of things in your estate plan. So that's something that should trigger you to come in and have a discussion with us. Significant changes in your assets or your health. Maybe incapacity wasn't something you weren't really worried about before, but now that you've been faced with a certain kind of diagnosis, maybe things have become more real. Maybe, God forbid, you've been diagnosed with something that might end you up in a care facility, sometime in the not too distant future, that might require you to want to seek Medi-Cal benefits. That's Medi-Cal planning is something that we're equipped to help you with. Trying to help people qualify for Medi-Cal through estate planning that might not normally be able to qualify. This can be really important if you have, say, dementia and you're going to potentially end up in a skilled nursing facility that can cost, upwards of $15,000 a month in most places in California. Definitely those are reasons to come in and relook at your estate plan. Relocation, if you move, like I said, your estate plan is going to be good no matter where you go. But if you're going to move, there might be other legal considerations to think about. So it's worth talking to us about. Changes in law. Laws change every so often. For instance, Prop 19 is something you might know about that went into effect, a few years ago that greatly affects the consequences of leaving certain kinds of property to your kids and the property tax consequences of that. The Secure Act, both 1.0 and version 2.0, 2.0 go into effect in 2022, can affect how retirement accounts need to be treated if they're getting funneled through your trust. So there's always changes in law that come about. And if it's been some time since you've looked at your estate plan or discussed it with an attorney, it's a good opportunity to come in and make sure that there's no changes in law that you should be aware of that need to be reflected in your estate plan. In conclusion, hopefully, that fire hose of information were still with us. At this point, I definitely appreciate your time. How can we help? We are here. We've been here for since the 70s, since 1979. And we're, like I said, have multiple departments and 12 different full-time attorneys to help you come up and uniquely tailor a plan that fits your needs. We're here to schedule an appointment with you to discuss your unique needs and find a plan that uniquely meets those needs. We can help you with strategies to deal with all sorts of situations you might have with your beneficiaries. We're here to help with if you do need advanced planning because your estate is potentially going to wind up paying some of that 40% estate tax. We're here to help you craft strategies to minimize that and potentially eliminate that. We'll help you to just be, part of what an attorney is there to do. They call attorneys counselors. And we at Copenbarger really take that seriously. We're here not only to discuss the bare bones legal ins and outs, but to really help discuss, this is about your life and what you value. And we're here to try to help you walk through that and help counsel you, sometimes in making very difficult decisions. Like I said, we not only have been open since 1979 with 12 full-time attorneys, we have attorneys with advanced tax degrees. We have certified specialists. We have over 45, members of our highly qualified support staff, and we have 8 different office locations for your convenience. Plus, we can always meet in Zoom anywhere, even if you're on the other side of the world. As long as you're a U.S. citizen, I can still meet with you over Zoom, and we can come up with an estate plan for you. So at this point, I'm going to open things up to questions. I'm going to start looking at that Q&A. And then once I go through the Q&A, I'll just check and see if there's any other questions I might have missed in the chat. But I do want to make sure that you're aware, this slide right here, we do want to hear from you. So it's really, really important for us to get your feedback. We really want to know if these presentations are helpful. We want to be serving our client base and make sure that these are of value to you. So if you wouldn't mind, please filling out the digital evaluation. Please check the link that will be posted in the chat. Please click on it and please, please, please fill it out so that we can get your feedback. This webinar, as I mentioned before, but I want to highlight, qualifies you for a free estate planning consultation. So you can sit down with me or one of our other estate planning attorneys, and we can pour over whether you've got an estate plan you want to review, or whether you've never done any estate planning. You have a free appointment with us to go over things and dive deeply into what your unique situation is and try to come up with a plan that meets your needs. So please take the opportunity after this, if at all you think you needed to schedule an estate planning consultation so that we can help you out. At that point, or at this point, I'm going to open the Q&A. Will you have Medicare planning as well? So typically the kind of planning we're concerned about there, I think, would be actually Medicaid planning, or in this case, Medi-Cal planning. Medicare is typically going to be more about the public insurance option, the insurance side of it. Medi-Cal is going to be more of the supplemental funds that can be available for certain things. As you might be, what you might be thinking about is especially important, as I mentioned, for our clients. If somebody ever develops a situation with dementia or Alzheimer's and they might need to be in a skilled nursing facility, that can severely drain the estate. If you're paying upwards of $15,000 a month to keep somebody in that kind of a facility. And Medi-Cal is money that can be available to help with that. The only thing that could potentially get in the way of that is your assets, and we can help do, absolutely, we are here to help do Medi-Cal planning. It's a type of advanced planning we can do to help qualify you for Medi-Cal, even if you have assets that would normally get in the way of qualifying for Medi-Cal. The next question, do other states have similar rules? If we move out of state, do we have to redo the trust? Other states certainly have similar rules. Every state has a probate court with their own probate rules. Everything's going to be slightly different, but the basic legal principles are pretty much going to be the same across every state. I will say, and I did mention this before, but just to be clear, because of the full faith and credit clause, your trust, if you do it in California, will be valid no matter where you move across the United States. It will be valid to keep your estate out of probate, whether you're in Alaska or Florida or California. The only wrinkle is, and again, hopefully your trust will keep things out of court, but if someone were to litigate about something about your trust and force you at least at some point in time to be in court about the trust, a California trust will have to be interpreted according to California law, but other state courts are equipped to do that. It's very common. People move. It's not a big issue. So if you do an estate plan with us and you move to Florida, it's no problem. Your estate plan will be fully valid and it'll still be there to do what you need it to do. Will we get a copy of all the slides used in this presentation? I know for a fact that we've recorded this presentation. Whether or not the slides separately will be available, I actually don't know for sure, but I assume somebody like David may have already answered that in the chat, but somebody from Copenbarger will probably answer that actually in the chat for you. Next question, we would like to make an appointment if possible. So I'm not going to read the name of the person. I see that this is very specific. Yes, you will have the ability to make an appointment for your loved one. If you want, just please follow the process to set up an appointment with us and let us know that you've attended the seminar, and we can get her in to do a free seminar just at your convenience in whatever office, or if you need Zoom is also a possibility as well. How can we get the recording, or is that not that we, like I said, we are recording this. The recording will be available on our website. If you have more specific questions about that, you can always, that can always be addressed in the chat. I am not really the tech guy. I'm the guy that hopefully has the legal knowledge, but at the very least, it'll eventually be available on our website, and I think on our YouTube channel as well. If there's any other way to access it, then I'm sure the staff will step in and put something in the chat or in the Q&A about that. Now, it looks like there's a lot more things in the chat, so I'm going to open up the chat at this point. Let's see. And again, for those bearing with me through all this, I really appreciate your time. Thank you for choosing to spend the time with us today. Let's see. Things about the webinar recording. Yes, it will be. I think another person was discussing, I think that was the same person asking about setting up an appointment for a loved one. Medicare planning, I did address that, technically Medi-Cal planning, but yes, absolutely. Yes, as Trish noted, if for some reason you have a question that doesn't get answered, you can always email a question to trish@copenbarger.com. Uh, so someone says, I've heard do not put IRAs into the trust. And they have 10 years to remove all the money. So IRAs, certain assets like IRAs, 401ks, 403bs, and life insurance policies technically cannot be titled in the name of the trust, like a house or a normal checking or savings account can. Sometimes they can still go to fund a trust through a beneficiary designation. So there can be reasons to, in certain cases, where we would strongly encourage you to set the trust as the backup beneficiary, for instance, after a spouse, to set the trust itself up as a beneficiary on that IRA or 401k or whatever the account might be. And so in that way, that asset still might fund the trust just after you pass away. The 10 years you're referring to is part of the consequences of something called the Secure Act, typically speaking, with very few exceptions. And if there is an exception, like, a spouse or if you have, a beneficiary with certain kinds of special needs, they can potentially qualify for an exception. But in general, because of the Secure Act, an inherited IRA or, Roth IRA or 401k are going to have to be fully distributed within 10 years of the person passing away. Uh, let's see. What is the procedure for adding something to your trust, or everything else? So as I touched on before, funding the trust, and I do actually have a webinar. Again, a shameless plug. I do have a webinar just about funding your trust and going into detail about how to fund the trust with different assets. That means how to put assets into your trust. That should be available on our website and I believe on our YouTube channel. But that said, typically a 529 account, anything beneficiary designated is typically, as a general rule, not going to be able to be in the trust. But insofar as you can transfer title to like a bank account or a house or a thing like that, typically what you're going to do, if you have a fully, drafted estate plan, there's something called a certificate of trust that, if you've got an estate plan with us, it's one of the documents usually in the front of your binder. And a certificate of trust demonstrates that there is a trust, that you have authority to do business on behalf of the trust, and it tells whoever need to know how to title assets being put in your trust. So you basically take that to the bank or financial institution you're trying to deal with, show them the certificate of trust, and say, I want to transfer this asset into my trust, and they'll retitle, the account into your name as trustee of your trust. So that's in general how you would move any sort of account into your trust. If the asset is a house, you're going to have to do a deed. So you're going to have to do a deed transferring it from you or you and your spouse, or however the property is currently owned. You're going to have to do a deed transferring it from however it's currently held to you or your spouse as trustees of the trust. And then that deed will have to be recorded. And that's obviously something that we can help you out with. Let's see. How do I find your YouTube site? I'm sure somebody will be able, if you type Copenbarger and Copenbarger in YouTube, I'm guessing you'll probably be able to find that, but that's something I'm going to rely on my staff to probably answer that question in the chat. But you can also watch it on our website. So every video, I believe, should be uploaded on our website. And if you have any questions about that, we can help you figure out how to access those videos on our website. It looks to me that we've about answered every question that's come in at this point. So if there's no other questions, let me see. Might have been a couple more that come in on the Q&A. Looks like there's at least one more. Somebody's in Washington State, but planning on moving to California. Should you wait until you move or get started on the living trust now? I mean, my general advice is always going to be against waiting, because my concern is that if I ever give you advice that you should go ahead and wait, is that you're going to get bonked on the head and something's going to happen between now and when we are able to do things for you. So there's no reason why we can't do a trust for you right now. So I would advise for you to either utilize the free appointment to set things up with us, or, if you want to, you can also see another attorney, but I would advise you to not wait until you move to California. We can prepare a trust for you even if you're living in Washington right now, and we can get that started right now. So I would just advise you to not wait. With estate planning, waiting is Waiting is what gets people in trouble because waiting for a day can turn into waiting for a year, can turn into waiting for 20 years. Even if you had the good intention to set up an estate plan, something can happen before you set up an estate plan, and then you're in a catastrophic situation. Is changing beneficiaries with addendums to the trust sufficient? Um, so technically what you're going to call a change to trust is an amendment, and there will be a procedure in every trust that says, essentially this is how you create a valid amendment to the trust. So long as any amendment is done in compliance with what's in the trust and with the provisions regarding trust amendments in the probate code, then that can function as a valid amendment to the trust. And essentially, if you do a partial amendment to the trust, you just keep the original trust, put the amendment sort of in your binder, hopefully that you have one if you have an estate plan, and you put the partial amendment on top of that trust, and you will then read the original trust in light of the partial amendment. But again, do it yourself. I typically do not advise just drafting your own amendments to the trust. It could work, but lots and lots of things can go wrong. And even if you do it in a way that will hold up to court scrutiny, should that ever happen, if nothing else, you can do it in a way that looks confusing. And the last thing you want is confusion when your family's trying to administer your trust after you pass away, because often that's going to lead to fighting. So I would advise in general that you see an attorney and do a formal amendment to your trust whenever you want to change something important, like your beneficiaries or your successor trustees or anything like that. I would advise you to see an attorney and do a formal amendment. I'll give it another second to see if any other questions trickle in. Okay, I believe that we've addressed all the questions we've had so far. Again, for the people that have stayed on for me to answer the questions, I really appreciate you choosing to invest all your time with us. I very much appreciate it. If you would be so gracious, I would again request, if you haven't already done so, to fill out the digital evaluation to let us know how we did. We definitely review those, and it's very important for us in trying to plan these things to make sure that we're actually really servicing our clients in a way that's most helpful to them. And again, personally, I really appreciate you choosing to invest your time with me. I hope this was helpful for everybody, and I hope I get to see some of you in appointments soon to discuss your estate plan. Thank you very much, folks.